Hello, everybody, and welcome. My name's Liz Baker. I'm from EGFR Positive. It's really nice to have you here tonight. We've got people from other charities too. I'm from EGFR Positive. We have Oncogene Cancer Research joining us tonight. We have also the people from Roy Castle and other people who follow us on social media, including some from the new charity ROS1ers, I believe. So thank you very much for coming. Thank you for Sarah and Yvonne for facilitating this and introducing us to Colin. So without much further ado, I will introduce Colin. He's our expert tonight. He's from an employment solicitor who's legal director at Cole Khan Solicitors in London. So thank you very much for joining us, Colin. I won't outline your area of expertise because I think you'll do that better than I will. So I'll hand over to you. And if anybody doesn't want to be recorded, please do feel free to turn off your cameras. Thank you.
Okay, thank you very much for the introduction, and good evening, everyone. I'd like to thank EGFR Positive for inviting me and Sarah for organising this and facilitating. Just by way of background, so you do know who's speaking to you, as it was said, I'm Colin Davidson. I'm a solicitor and legal director at Cole Khan Solicitors. We only deal with individuals in employment disputes. Outside of this role, I sit in the committee of the Discrimination Law Association, of which I was previously chair, and also sit on the board of Equally Hours, which is an umbrella charity that brings together a host of other equalities charities throughout UK. I have spent the last 12 years working in employment law and specialising in discrimination and disability discrimination in particular. So my real goal, despite what you might know about lawyers, is not to rack up billable hours, but to try and advance protections in the workplace. As such, I see this evening as an extension of my role, and I really am very happy to be here and to be able to speak to you about employment rights in the workplace following a cancer diagnosis. I'm going to go through the law, as of course I'm a lawyer, and that is the source of your legal rights at work. And some of this may come across as a little bit dry, but I'm going to try and develop this from the black letter law onto some practical examples of what these rights mean in the workplace and what you can do to make your working life more comfortable. I'm going to be making comments about bringing legal claims, as unfortunately that's where we normally get involved, and that is my experience. But however, this endpoint is also a useful tool to work back from, to see where your protections, where you can protect yourself in the workplace and take preemptive steps so that hopefully you don't need to end up seeking advice from me and ending up in an employment tribunal. I'd like to say that it's not always evil organisations or terrible bosses that discriminate against workers, although it can be. More often than not, an employer is simply unaware of their responsibilities and your rights, or they're misguided in how they seek to manage the situation following being informed of a diagnosis. But regardless of what happens, the impact can be the same, and it can be life-changing for the individuals infected. So the point is, the last thing you need following a diagnosis such as cancer is more problems. You need support, you need a sense of structure and a sense of normalcy. So knowing your rights not only equips you to fight back if you're facing discrimination in the workplace or harassment, but it offers you the opportunity to work with your employer to ensure a safe and supportive workplace. There's also support for carers, but that is not something that I'll be delving into today. And so looking at the first slide, which I believe deals with the Equality Act 2010. So this is where your primary protection comes from in the workplace, the Equality Act 2010. This actually brought together 116 different acts, such as the Sex Discrimination Act, the Equal Pay Act, and the Race Relations Act, and the Disability Discrimination Act. As such, this was a historic piece of legislation when it was brought in 2010. This is a key piece of legislation to understand discrimination throughout the course of your life and your interactions with society, because different parts of it cover different interactions. So Part 3, for instance, deals with public functions such as governments. Part 4 deals with housing. Part 5 deals with employment, and Part 6 covers education. So as such, much of what I'm discussing tonight about the protections in the workplace may be applicable in other situations, say, such as housing issues or education. So you can refer back to this. We, of course, will be focused on employment and work-related situations in part 5. And that is that the principle that people with a protected characteristic, such as a disability, should not be discriminated against in employment when seeking employment or when engaged in occupations or activities related to work. Now, it's worded precisely that way because it covers instances where you might not necessarily be an employee. You may be a worker, a contractor, or a job seeker, or even after employment in the provisions of references. So this covers the entire lifespan of your working life. The Equality Act is not easy reading. It's built for lawyers, and so there is guidance that allows you to navigate this. There's guidance issued by the government, which interprets the language, but there's also guidance by the Equality and Human Rights Commission, the EHRC. They issue a code of practice, which is statutory and which must be taken into account by courts and tribunals, but they also offer practical guidance. And this is for workers and employees, which assumes no knowledge of the law whatsoever. And this is the most helpful reference point for the layperson who might need an introduction to the Act. So if you're querying anything I'm saying tonight and you want to look at the Equality Act, I would start with the EHRC guidance, which you can find on their website. I've put up there the Employment Rights Act 1996 as well. That's where a number of employment rights come from, but they mostly deal with kind of ordinary unfair dismissal, wages, things like that. When we're concerned with discrimination, we're looking at the Equality Act. And I'll move on to the next slide, please, which is what is a disability. So within the Equality Act, there are 8 protected characteristics, and it's these protected characteristics to which all the legal rights assign. Disability is one of these protected characteristics, and I have up on the screen the legal definition of disability. Now, it's important to understand at the outset that in these circumstances, disability is a legal term and not a medical term. There may be some stigma associated with labeling someone as disabled, and this may be particularly relevant where you're dealing with something like cancer. However, first and foremost, you need to understand that it's a gateway to rights and protections under the Equality Act. So don't be afraid to embrace this term for these purposes. Now, not every condition will necessarily meet the legal definition of disability, because you can see up there that there is some hoops to jump through. For instance, a broken leg is not a disability because it doesn't meet the threshold of long term, because it will heal in less than a year. Cancer, however, is a deemed disability. It's legally considered to be a disability, and you don't need to jump through any of the additional hoops in that legal test. This is confirmed in the government guidance. It's not contained in the Act itself. And the HRC code confirms that cancer is a deemed disability from the point of diagnosis. Now, some confusion may be caused by the reference to the point of diagnosis. For instance, if a person attends a doctor and is informed that she has cancer and it's advanced and it must have been present for, say, 6 months, what is the point of diagnosis? Is it the point where the medical evidence shows that the person first had cancerous cells, or is it the date 6 months later when the diagnosis was pronounced? Now, what the case law tells us is it's clearly the former. And for the purpose of the Equality Act, it's the earlier date from the deemed disability began. It is the point from which cancerous cells are present, and not from the point that you're told about the diagnosis. And so that means that if an individual has cancer and the employer has actual or constructive knowledge of this prior to an official or medical diagnosis, that protection still applies. Now, looking forward, while the case law isn't actually settled on this point, there's sufficient evidence to suggest that a person diagnosed with cancer continues to be protected as disabled, even if after successful treatment there are no cancerous cells present in the body. Now, that's relevant for things like harassment or reasonable adjustments, which may be required after the point of successful treatments. If you're harassed for having had cancer, for instance, you will still be protected under the Equality Act, even if the treatment has been successful. Now, I spent a little bit of time on that point because it's important to realise that your protections under the Equality Act arise out of establishing that you have a protected characteristic. And in this case, the protected characteristic is disability, i.e., that arises out of your cancer. So I urge you not to shy away from the word in establishing your protections, because I understand that that can be some stigma attached to it. Now, moving on to the next slide about informing your employer. I fully appreciate that, not everyone would necessarily want to inform their employer immediately that they have cancer, and that they've been diagnosed, and you're by no means obliged to do so. I do understand that there's any number of reasons for not informing your employer, which are wholly legitimate, from pride to privacy. However, to secure a number of your workplace rights, your employer does first have to know that you have a protected characteristic, i.e. disability, i.e. cancer. Um, I will highlight as I go through some of the specific legal protections, which ones require knowledge and which ones don't. However, in some of them, it can be a complete defense for an employer to show that they did not know and they could not reasonably been expected to know that you had cancer at the relevant time. So it is important, if you're comfortable to do so, to inform your employer, and you may be doing yourself a disservice by not sharing your diagnosis. The HRC code again is helpful in this point, as it says that if you haven't explicitly told your employer, but you are seeking to rely upon the Act, it states that an employer must do all they can reasonably be expected to do to find out if you have a disability, if you're placed at a disadvantage. Basically, this means that if you have a disability and you're looking unwell, and you're showing symptoms, an employer cannot simply look the other way or bury their heads in the sand as you've not explicitly said that you have cancer. They are under an obligation to make reasonable inquiries. Now, that is of course balanced with the issue of privacy and so they may not want to be intrusive, but they do have to make reasonable inquiries. As I say, you do still have a right to privacy and confidentiality, and any disclosures you do choose to make to your employer should be shared no more widely than is necessary to protect your rights and to implement the adjustments you need. So that means essentially having a frank conversation with your employer about how widely you wish for your medical history to be shared. You may wish this to be contained to very specific individuals, or it may be your choice that you're speaking freely with your colleagues about this. Many employers have what's known as a disability passport, which records the diagnosis and it will record any reasonable adjustments which have been agreed. And you can decide on how widely that should be shared. Should that be shared with only specific managers, or who should have access to that? Your medical information is protected under the GDPR UK and the Data Protection Act 2018 as special category data, so special rights apply to that. The Access to Medical Reports Act 1988 also says that your employer must ask for your permission to get a medical report on your health. So that's applicable to things like occupational health reports. And you have the right to see any report before it's given to your employer. Well, certainly you have the right to ask to see any report before it's given to your employer, and you have the right to refuse permission for occupational health to give your employer that report if you don't agree with the contents of it. And I'll move on to the next slide. So we're coming on to the first specific protection that's under the Equality Act, which is direct discrimination under Section 15. And that's on the next slide. So direct discrimination is the most commonly known form of discrimination claimed. However, as we'll come on to see, it's not always the most successfully used. Direct discrimination is where you're treated less favourably than a colleague because you have a disability or any protected characteristic. So for instance, your employer cannot take you off a project because you have cancer, and that would be less favourable treatment, i.e. being taken off the project, and it's because of a protected characteristic because you have cancer. However, it's very rarely as explicit as this. An employer will generally not say they're taking specific action because you have a protected characteristic or because you have cancer. Often it is because of an assumption, a kind of a wrongly assumed that you cannot do the same job or that you'll be less committed and they will not say that. And so it is often very difficult to get to the reason why someone has made a particular choice. Why have they treated you less favourably? Because with direct discrimination, you have less favourable treatment and you have a protected characteristic, but you need to make that connection. It's the reason why they did that. And that involves a judge kind of looking into the mind of, the decision maker. Why did they make that decision? And it's often difficult to kind of look into the mind of the decision maker. Judges will often be very wary as well of labeling someone as a discriminator. People don't like to say that about other people generally, and so they'll seek to ways to avoid that. So what you have to do is build a picture of discrimination, and that's normally done by building up an inference of discrimination from lots of little things, little comments or kind of little actions, to build an overall picture by which you can build that inference and connect those dots between the less favourable treatment and the protected characteristic. I would always suggest, if you have any concerns in the workplace, to keep a diary. It's very difficult to build that picture at a later date. You'll often, you'll have this deep sense of feeling that something is wrong, but building that picture at a later date is often very difficult. And so having a contemporaneous note of things that happen as they occur is invaluable, and you can show it to a colleague, you can show it to a friend, or you can show it to a legal advisor, and we can advise you on that and just say, well, no, when we connect these dots, it's quite clearly this has built a picture that is connecting the dots between the less favorable treatment and the cancer effectively. So moving on to discrimination arising from disability. In the next slide, this is under section 15 of the Equality Act. This is where you're treated unfavorably rather, because of something arising from your disability, not because of the cancer itself, but because of something arising out of the cancer. And a classic example of this is if you require time off for sickness or for appointments. For instance, using the same example, if you're taken off a project due to your extended sick leave, or for requirements to take time off for appointments, this could be discriminatory, because the requirement to take that time off arises out of your disability, i.e. your cancer. And also, unfavorable treatment is not the same as less favorable treatment. Less favorable treatment in the previous example of direct discrimination requires a comparator. You need to look at someone else and say, I was treated less favorably than them. Whereas unfavorable treatment is worded specifically that way so that you don't need a comparator. So it is a slightly easier test. And that is why this is used more frequently than direct discrimination. There are caveats to this. There's the proportionality test. An employer can say that they treated you a certain way because it was a proportionate means of achieving a legitimate aim. Now, a legitimate aim may be, they may argue that they need someone on this particular project for set times or for set hours, and therefore you taking time off during that period means you cannot work in that project during those set times. However, whilst that may be a legitimate aim, is that a proportionate means of achieving it? And so is it proportionate to need the project carried out within those hours or within those specific times? Has the employer considered that it could be done out of hours, for instance, outside of appointment hours, or on odd days, every second day, for instance, and finished within a different time frame? Just because that's the way they've always done it, it doesn't mean it has to be done that way, and it doesn't mean it's legitimate to do that way. So an inquiry has to be made into whether it is a proportionate way of achieving that legitimate aim. That will come into the question of whether the employer has considered reasonable adjustments. And it may be a reasonable adjustment to change the hours, and we'll come on to the specific claim of reasonable adjustments later. Second caveat to this is that your employer needs to know that you have the disability of cancer. I mentioned this earlier, and it can be a complete defence for your employer to say that they simply didn't know that you needed that time off because it arose out of your requirement to go to appointments because of your diagnosis or because of your treatment. And so they just thought that you were taking time off, and that may be a complete defence. So again, it is important to have a frank discussion with your employer if you feel comfortable to do so. Now, the HRC code gives another useful example. of what may be discrimination arising from disability. For instance, if you lost your temper at work, and that loss of temper arose out of severe pain caused by either the cancer itself or some treatment, and that was a consequence of your disability, and that was kind of out of character of something that it was attributable solely to the disability or your treatment, then that may be discriminatory, because that's something that arises out of your disability and may be discrimination arising from disability. The next claim here on the next slide is indirect discrimination, and this is found under Section 19 of the Equality Act. I'll start by saying that there is no lack of knowledge defence for indirect discrimination. So this is one that may be open to you if you have not informed your employer of your cancer. And so that's an important piece to keep in mind here. Unlike direct discrimination, however, indirect does not involve treating workers differently. Rather, it's type of discrimination that arises that although employers treat all workers the same, some aspect of that uniform treatment affects one group of workers adversely compared to the others. Basically, what that means is about applying a policy to all workers which affects you more because you have cancer. The PCP in the test there basically is a fancy and more detailed way of saying policy. And so just to give a worked example to bring that to life, an example might be that, if an employer insists, for instance, that workers with a particular job function must work on the 5th floor of a building and there's no lift, this would make it difficult or impossible for people who, say, have wheelchairs or who suffer from fatigue from making it to the 5th floor. So that policy would be indirectly discriminatory, because whilst it applies to everyone uniformly, it only affects those who, say, for instance, have wheelchairs or suffer from fatigue arising out of their disability. Another more practical example is that if an employer insists that all employees have to work from the office every single day, this may affect people, again, if they suffer from fatigue, or if you're seeking to manage your treatment at home, and that you need some time for home working. So that is a policy which may apply to all, but would affect you more because of your disability, and that would be indirectly discriminatory. Now, again, there is a defence to that of being a proportionate means of achieving a legitimate aim that I discussed in the previous example, and so there are defences to this. And indirect discrimination is not frequently relied upon in employment tribunal claims, at least not as the principal claim, because, as we'll come on to, most factual circumstances will fall under either discrimination arising from disability, which is what we just discussed, or it will fall under failure to make reasonable adjustments, which I'm just about to come on to. But this will be a useful tool if, as I say, you haven't previously informed your employer about having cancer because they don't have the knowledge defence. So moving on now in the next slide to reasonable adjustments under Section 20. Reasonable adjustments are effectively the crown jewel of legal rights and protections in the workplace if you have a disability. And I'll spend 2 slides on this because they are extremely important. This duty requires employers to take positive steps to ensure that disabled workers can access and progress in employment. This actually means treating those with disabilities more favourably than non-disabled workers. What we're primarily concerned with here, again, is whether there's a policy or a PCP that puts someone with cancer at a substantial disadvantage, as would the example previously as mandating 100% office attendance, or, for instance, maintaining a certain level of attendance, i.e. sickness management policies. These, again, are policies which apply equally to all employees, but which may put people with cancer at a disadvantage. The employer then has a positive duty to make a reasonable adjustment to allow to remove that substantial disadvantage from the individual with cancer. Now, what that looks like in practical terms, as I said previously, may be to allow the individual to work from home for a certain portion of the week, so that they can either recover from fatigue or manage their treatment. And the second slide we'll come on to in a moment, that has some more practical examples. But this is a positive duty that the employer has to implement, and that duty applies to them whether or not they're aware of the duty. There is an obligation on the employee to make suggestions for adjustments though as well. There's no obligation to consider what adjustments are needed by the employer. So there is an obligation for the employee to make suggestions of adjustments. Now, again, going back to the EHRC codes, that provides some pretty useful examples. And they also provide examples of what would be reasonable in these circumstances. Now, it's called a reasonable adjustment for a reason. And so there has to be a balancing exercise of what an employee or a worker might want, whereas what is reasonable for an employer to make as an adjustment. And the considerations that the EHRC suggest is financial costs is a big one. Now that has to be balanced against the resources and sizes of an employer. So basically, if it's a low cost adjustment, such as working from home, there's almost no cost to that whatsoever. Then there doesn't appear to be a reason not to make it unless there's a legitimate business reason to be in work. However, if it's a high cost, such as putting in adjustments to the workplace, building ramps and things like that, and that sometimes has to be balanced against the size and resources of the employer to decide whether it is in fact a reasonable adjustment. So financial costs is a concern, but it has to be balanced against things like the size and resources of the employer. It also has to consider whether taking any step would be practical in preventing the substantial disadvantage. So it actually has to remove the substantial disadvantage, because if it doesn't, then there's no point in making that adjustment. This is where things like occupational health reports would come in useful, because an occupational health report can suggest adjustments for the workplace if a manager isn't aware of them. So coming on to the next slide, I have put some further examples on the screen of what might be reasonable adjustments. And again, if you want to do any homework, I would suggest going to the EHRC guidance, which provides worked examples of this. So think that, yeah, so just again repeating that, to be reasonable, it has to have a real prospect of preventing the disadvantage. So the employer is not required to make an adjustment that has no real prospect of alleviating the disadvantage. Now, comparing two examples here, for instance, a sickness absence or attendance management policy which requires a certain level of attendance, that is, as I said before, going to put a disabled worker at a disadvantage because they may need more time off. And so making an adjustment to the trigger points for when the sickness absence policy might kick in would be deemed to be a reasonable adjustment. However, unless in exceptional circumstances, it's not a reasonable adjustment to extend someone's sick pay if they're off sick and have exceeded the maximum limit of that and they've gone on to nil pay. Now, the reason for that is because paying someone to stay off sick effectively is not facilitating them engaging in the workplace. And so it's not assisting them to get back to work. So generally, that's not seen to be a reasonable adjustment. The only exception to that I found is that if the reason for someone being off sick is because of the discriminatory treatment of the employer. So for instance, if an employer has failed to make a reasonable adjustment, and so the individual cannot engage in the workplace, then it would be reasonable for the employer to pay that person whilst they're off sick until they've made the adjustment that allows them to come back to work. But that's one of the very infrequent examples. Now, moving on to the next slide, harassment is another claim which comes up quite frequently. This is unwanted conduct which is related to relevant protected characteristic, i.e. cancer, and which has the purpose or effect of violating the worker's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. Now, there's no requirement for the mental element equivalent to that, which is in direct discrimination. So if the purpose of someone who is harassing an individual is to violate their dignity, then clearly the perpetrator of that would be guilty, even if it did not have that effect. For instance, so if they were trying to kind of harass you, and it didn't have that effect, they can still be guilty of harassment and they can still bring a claim. But even if it wasn't their purpose, so the mental element isn't there. They didn't mean to harass you, but they made a comment which, created a hostile environment, or was, humiliating effectively. Even if they didn't mean that, if it has the effect of violating your dignity or creating an intimidating or hostile environment, then that is still harassment, and the perpetrator will still be liable, even if that wasn't the purpose of the conduct. And so it is a slightly lower threshold than direct discrimination. And it is very useful in that regards, because quite simply, a lot of people can be insensitive with their language, and they can create, intimidating and hostile environments without necessarily meaning to do it. There's not necessarily malice there, but whether it's ignorance or some other reason, it's creating the prescribed effect, and it's creating an atmosphere which is intolerable effectively. That would amount to harassment. And there's some interesting examples that go through the guidance, and I'll just give you one here just now as well. So the conduct viewed in the abstract may be completely innocuous in nature. For instance, a manager who always assigns minute taking at meetings to one person present who is in a wheelchair could be liable for disability harassment, even though the task of minute taking viewed in isolation is not itself degrading or humiliating. So I think that you can see there that the intention may not have been to humiliate this person, but the effect may be to humiliate this person because they're always assigning that kind of that task to that individual. Harassment also looks at the cumulative effect, and again, I refer back to the point about keeping a diary and building a picture. One individual act which may itself not amount to harassment when looked at in isolation, when looked at in building a picture of lots of different acts, may amount to basically a hostile environment. So it's building a picture of a lot of kind of little things that kind of chip away, and eventually what you're left with is just a lack of dignity in a kind of hostile environment. So again, it comes back to the point about potentially keeping a diary, because often you will feel it yourself, but you can't necessarily put a finger on it. But when you look back over a diary of all the individual things that have been said to you, you may find, actually, looking at the big picture, this is a hostile environment. Coming on to the next claim, which is victimization, under section 27. The test for this is on the screen. But this is, where someone is subjected to a detriment, basically, because they've done a protected act, or they may do a protected act, or someone thinks they may do a protected act. Now, a protected act is doing anything for the purposes of or connection with the Equality Act. And what that means in practice, realistically, is making a complaint about discrimination. So if you were to raise an informal or a formal complaint in the form of a grievance, for instance, and claim that you were being discriminated against, and then you were treated badly as a result of that, then that would be victimization. And the purpose of this is obviously to protect individuals when they raise their head above the parapet and kind of speak out and say that this is not fair, this is discriminatory treatment. So for instance, if you were to complain about being discriminated against by a manager and then you were terminated, and the manager said basically that they didn't do it because you had cancer, but they did it because you had the impertinence to suggest that they had harassed you, then it's because you complained about that harassment that is actually the reason. And so it's not a claim about harassment, it's not a claim about direct discrimination or failure to make reasonable adjustments. It's you were terminated because you complained, and that's victimization. Now, you may have other claims. The harassment claim originally may have been a good claim, but even if it wasn't, even if that individual hadn't originally harassed you, but you complained about harassment, then you could be victimized. So the original complaint doesn't actually have to be doesn't actually have to succeed, but I mean you have to genuinely believe it. You know, you can't be just making a kind of bad faith complaints. But if you are complaining about harassment and you're terminated, then that could be victimization. What is helpful about this as well is that the individual making a claim for victimization doesn't have to hold the protected characteristic. And what that means is that if a colleague is complaining on your behalf, if a colleague raises a complaint on your behalf and is then subject to detriment, terminated, or kind of disciplined, then they could have a claim for victimization, even though they don't have that protected characteristic. So it is helpful to protect colleagues who may be allies. So moving on to the next slide, I've gone through the main protections in legal terms under the Equality Act. And so now I'll just come on to some kind of practical considerations that arise out of this. It was a bit of a whistle-stop tour, and I appreciate that there's a fair bit of technical detail in there. It was somewhat just to whet the appetite, and as I say, I would refer you back to, if you need more detail, the kind of EHRC guidance in that, or obviously you can take advice on these issues. But I would advise that you take early advice if you have any concerns about discrimination in the workplace. But the issue is, if you're speaking to me, it's likely that something's already gone wrong. And so what we are trying to do is manage the relationship so as not to get to that point. As I said right at the outset, I think that you should, if you feel comfortable, speak with your manager or a trusted colleague about your needs, about the diagnosis, and about what you think you need moving forward. If you have a union, I would advise you to speak with your union and seek support. Again, all of this can be done confidentially, and be clear about your confidentiality requirements, because they are protected. I mean, the reality is that in the workplace, it will be a challenge. I mean, could be suffering from fatigue, pain, requiring time off for appointments. You will have needs that, whilst you may not feel comfortable sharing at the outset, the reality is to make it a more comfortable environment, it may be necessary to do that. And you do want buy-in from your employer, which can be a two-way street. Coming back again to the point about occupational health, it is useful to get a referral to occupational health, because whilst they ultimately do have a contract with employer, they are medically qualified to give advice on adjustments in the workplace. And their job really is to bridge the gap between complex medical situations and the realities of work, and they are uniquely placed to do that. You can seek to maintain your privacy and confidentiality, and as said, the Medical Records Act allows you to keep confidential your medical disclosures, and you see reports prior to them being shared with your employer. So concerns over privacy should not be a barrier to you getting support. And again, just repeating that your employer cannot know to make adjustments if they don't know that you're disadvantaged in the workplace, and so you do have to make them aware of that. If it gets to the point where you are concerned about issues in the workplace, such as harassment, you should raise these with your employer or a trusted colleague. I would suggest that you seek out the grievance policy and go through the stages. The first of that normally is always raising things on an informal basis. And if you do have a trusted kind of manager you can go to, I would suggest that you do that on an informal basis and see if it's something that can be resolved at an early stage. And particularly if you're seeking to preserve employment, which often is the case at an early stage, going through it informally will allow you to kind of preserve relationships, potentially look at things like mediation if that's required. If that doesn't resolve the issue, of course, I would suggest that you go to the formal stage and you lodge a grievance. It may be, if it's serious at that stage, you want to take advice. Your union or a legal advisor can assist you with that, even if it's advising you to lodge it yourself. Again, advise keeping a diary of notes, at least, of what is happening, so that you can refer that back to that at a later stage. Having contemporaneously notes is extremely useful. You may also want to consider things like lodging a data subject access request if you are not getting access to your data. I would suggest that if issues do arise, don't resign before you take advice. it's much easier to advise and secure an exit if that's what you're seeking whilst you remain employed, than to negotiate after you have left. That's not always possible, but that would be our advice. You want to consider obviously whether the situation is salvageable, whether this is an employer that you want to remain with, or whether that boat has sailed. And that can be, a real situation, but we can advise, or your union or someone can advise you on that, about whether the irreparable damage has been done. If we do get to that stage, on the next slide, I'll talk about, looking ahead to potentially going to the tribunal. While the primary position is to resolve matters without legal proceedings, you do need to be aware of the tight time limits to bring a claim in the employment tribunal. And these are extremely tight. You only have 3 months minus a day from the date of the act complained of to contact ACAS. ACAS is a conciliation service, which seeks to conciliate between the parties trying to avoid a tribunal claim, but it is a mandatory step prior to bringing an employment tribunal claim. And as I say, they have to be notified 3 months minus a day from the act complained of. Now, if it's a simple single discriminatory act, such as a termination, for instance, if you've been dismissed, or if it's a particular harassing comment, it's easy to calculate that date. However, if it's a failure, such as a failure to make reasonable adjustments, this can be more complicated because there's a question over whether it's the date that someone decided not to make the adjustment, or if they've simply failed to make the adjustment, that could be continuing over a period, whereby the failure is a continuing act, and that can make things more complicated. If there's a series of acts as well, if there's a number of harassing comments, time may run from the end of these comments and bring all the earlier comments in time. And so time is quite a complex issue. So unless you have a quite definitive act, such as one specific comment or a termination, I would suggest, if you've got any concerns over that, you seek advice from your union or a legal advisor. Because if you miss the boat effectively on lodging in time, you may have stopped yourself from bringing a claim in the future. There's complex rules in relation to extending time, and should we need to, we can go into them, but it's not time for that today. So moving on to the next slide about employment tribunals. As I say, the employment tribunal is generally a last step if either the situation is unsalvageable, or you've already left employment, or if there's an issue about time limits. And when you're going to employment tribunal, you have to think about the kind of cost versus benefit ratio effectively. It's a very practical thing that needs to be considered. I start off by saying that the employment tribunal is not a cost shifting forum, which means it can be helpful because it means if you lose, you don't pay the other side's costs. However, if you win, you still have to pay your own costs. And so you have to balance what you may get out of an employment tribunal against what you may pay to go through it. Unfortunately, lawyers are not cheap. And so it is a very real consideration that you have to assess right at the outset. Obviously, a legal advisor can assist you with that. I will also just underline that going through legal proceedings is an extremely stressful experience, and often not what you want to be dealing with, whilst also dealing with a diagnosis or going through treatment. So you do want to think very carefully about whether this is the right avenue to go down. You also want to consider what you can achieve if the relationship is ongoing. If you're still in employment, obviously tribunals can be they're conflict ridden. It can bring an end to that relationship. However, it can also offer things like declarations and recommendations. And so a recommendation, if an employer has failed to make a reasonable adjustment, and you're determined that there is a reasonable adjustment that they've just failed to make, and a tribunal can make a recommendation that they make that adjustment, and if they don't make that adjustment, can then hold them legally liable for that. We have experience of that in a previous case. Against the Metropolitan Police. I represented a police officer who had a heart condition, and there was a history of kind of racial abuse and racial complaints, which meant that he couldn't go to the workplace effectively because of his heart condition and the real and genuine fear about having a heart attack. He was refused a flexible working to work from home without any operational requirement for him to be in the office. He wanted to maintain employment because it was the only role he'd ever known, it was the only job he'd ever done, and of course there was pension considerations there as well. And so the benefit of that was actually securing employment. We got a recommendation that the Metropolitan Police adjusted their home working policy, and they updated it for police and staff to allow home working, or to at least to outline what the home working policy was. So that allowed him to preserve his employment and keep his work and his pension. And so, that was a very real consideration about whether you want to go to the tribunal or not, because even in circumstances where the financial cost may outweigh the benefit in compensation, there may be other reasons for going to employment tribunal, but that's something you would want legal advice on. And just coming on to the next slide, just to be clear about the types of compensation that are available. These are not always as generous as people might think and that the headlines might show you. The primary award for discrimination is compensation under what's known as the Vento bands. This is taken from a historic judgment of Vento versus, the Chief Constable of West Yorkshire Police. So again, this was the police being naughty, and that shows that there's these three bands that compensation falls into, and it's decided based upon the frequency of the discrimination, the effect on the individual, whether it ends in termination. And so there's a factual matrix that will go into deciding, which band it falls into and where the judge believes that the compensation should be pinpointed. I would suggest that the majority of awards kind of fall in that middle band of 12,000 to 36,000 roughly. There's a lot of low-level awards and a lot of high-level awards. But the eye-watering compensations that you often see from time to time in the papers mostly arise out of financial compensation for loss of earnings. And these individuals normally have extremely high salaries to start with. And so that has to be taken into consideration when you're thinking about what awards might be awarded. The tribunal is there to put you in the position that you would have been had it not been for the discrimination. And so what it's really looking at is when will you find future employment and how long will you be out of work for, and it pays you for that period. So if you, for instance, thought you were going to find work within 6 months, you would possibly be awarded 6 months pay plus some compensation in the Vento bands. So realistically, it's a very practical consideration of considering what the cost may be to go to tribunal versus what compensation you may be awarded. And that's a very real consideration that has to be looked at the outset and taken advice on. And again, I'll just reiterate that going through court proceedings is extremely stressful and potentially not what you want at that time in your life. And that is the final slide. The next slide is just for questions and answers. So hopefully I haven't sent you all to sleep.
Thank you, Colin. That was a really, really clear and practical discussion of quite a complex topic, I think. So thank you for doing that so clearly. I can see a few hands up, so I'll take questions now if that's okay. And I've got Richard, you've got your hand up.
Hi there. Yeah.
Hi.
Can you hear me? Okay, great. Thanks, Colin. First of all, apologies for logging in late. My computer was messing around, so I missed the first 10 minutes. But I caught up with the discrimination arising from disability and indirect disability discrimination as well. So I've actually gone through a solicitor now, and he's identified 4 possible cases for discrimination, including failure to make reasonable adjustments. I'm currently going through, so I put in a grievance that was rejected. So I've now appealed my grievance. because I've highlighted quite a few issues with the outcome of the grievance itself. So my main issue is that my manager hasn't not only not made the effort to make reasonable adjustments, but he hasn't. There is no evidence at all that he's tried to even make reasonable adjustments. And I've also evidenced that from an ICO request, where I got all the emails from what he's sent to my senior managers to see what, just basically to see what he's done to provide me with reasonable adjustments. And from what I've seen, there is absolutely nothing. He's provided absolutely nothing, even though he's been chased up himself to help me. He's done nothing. Now his argument is that I'm a tube driver, by the way. That's my main job. Now their argument is they can't give me reasonable adjustments because it doesn't substantive role. So their argument is, but we can't provide you with any reasonable adjustments because you're saying that you can't do your substantive role. Whereas I'm saying, but Transport for London has 30,000 people. You can surely put me in a temporary place, whether it's an office job. You know, I've got previous experience in project management and administrative work, but they're saying to me they can't do that. They can't even attempt to do that because it's not my substantive role. So that's what they're sort of standing on, and they keep using that argument. And I'm just wondering, would that still hold up really? And if it came to a tribunal?
Yeah, I mean, I'll start with the caveat because I'm a lawyer that this is not legal advice. But I mean, in one of the slides that I shared, examples of reasonable adjustments can be transferring to fill an existing vacancy. And so if there's an existing vacancy within the organization, it can be a reasonable adjustment to transfer you to fill that. Now, there may be a number of arguments about, you not being qualified for that vacancy or things like that. But then we come into the idea of, well, is it a reasonable adjustment to provide you with training to then allow you to fulfill that vacancy? So I don't think it's a complete defense for them to say that that's not your substantive role and therefore we can't transfer you to another role. There has to be a bit more of an investigation into what is possible. Because as I say, it's a clear example in the HRC that transferring to fill existing vacancy may be a reasonable adjustment. Taking a step back as well, I'm not quite clear whether you can or cannot do your operational job with adjustments, because it may be that some part of your job an adjustment can be made. Because for instance, it wouldn't initially strike you that a police officer could do their job from home, yet there's lots of police officer jobs that are entirely desk based, and so it is possible for an officer to do their job from home being transferred to another role. And so they have to apply their mind to it, and from the brief information that I have, it doesn't appear that they've really applied their mind to it.
Yes, so it would be a case of their argument is my contract is a train operator, so that's it basically. If I can't fulfill that, but like you say, if they haven't even explored the options of going into the other departments of the company overall. So it would. So you're saying it basically would be a case.
It could be. I mean, I think that it's called a reasonable adjustment for a reason, because it's a balancing exercise. And so you do have to, but they do have to apply their mind to it. It's not just there's effectively reasonable adjustments. Nothing is technically off the table, but it has to be decided whether it's reasonable. And as I say, in the EHRC guidance, there is a list of criteria as to decide whether something's reasonable. And an employer the size of TfL, they have lots of resources. I know things that may be not reasonable for a smaller employer may be more reasonable for a larger employer.
Yeah. Okay. No, thank you. Thanks, Colin. Thank you for the presentation. Thanks.
Thank you very much for that useful question, Richard. I'll move on to the next person who's got the hand up, which I think was Yvonne.
Hi there. So thank you so much, Colin. That was an excellent presentation, so thorough. My questions are more in hypothetical, and I wonder, with many of us with lung cancer, especially because we're diagnosed quite late, our needs continue to evolve. So reasonable workplace adjustments are not just at the start of the diagnosis. They might continue to evolve as we run through treatments and have to go on to new treatments, which have new side effects. So I guess, are those protections from the employer's standpoint? I just imagine they might think it's a one and done. I had this conversation and it's now fine, but I guess what are the protections there? Might they say, I already, adjusted you, you're done now? And so that's a question. And then a second part, which is completely unrelated, but we do see people seeking new jobs, right? Because they, were mistreated and eventually leave. And I guess, what are the obligations around disclosing? People lose confidence when they're trying to get a job and think, when do I have to tell them? Am I keeping a secret? And is that something, when are you obligated to share this? I don't know if you have advice there too. So two separate questions.
I'll deal with the second first, just because it's most recent. You're never under an obligation to share. I mean, it's your personal information. You don't have to share that. I understand why people don't share. It's pretty common for us to get involved at a point where someone's never told their employer about diagnosis, and as I say, for any number of reasons, whether it's pride or privacy. But it is helpful, obviously, for the reasons that some protections only apply once the employer is fixed with knowledge. One of the ones that I mentioned that doesn't need knowledge, for instance, is indirect discrimination. If a policy is affecting you because you need time off, that could be. So, I mean, it's a balancing exercise about, and frequently what we see is at the point of recruitment, for instance, people are worried about disclosing anything related to disabilities because they think they won't get hired, and that's very real. And so people will often wait until after they're hired and then disclose, but then they're concerned about seeing duplicitous and kind of not being honest at the point of hiring. So it's a real dilemma. I fully understand that. As I say, if you're comfortable, share it, because building a comfortable working environment, it means it's a kind of two-way street in terms of sharing that information so that you can get the things put in place that you need. And then coming on to your original question is that with any kind of a medical condition, it's a fluid situation. It can be, and I appreciate that, particularly with cancers and lung cancers, and that no, it's not. Their responsibilities don't crystallize at a particular point in time. And so if you have an evolving situation, then they have an evolving duty. What that may mean, though, is, as I say again, constantly informing them of your evolving needs. And what employers use is occupational health normally. And so if if your needs change, then that might mean a new referral to occupational health, because then the employer's fixed with that knowledge again of what your needs are. People are understandably wary of occupational health because it's seen to be a tool of the employer, but they'll often be asked a question such as, does this condition qualify under the Equality Act? And, cancer is one of these ones, actually, as I say, it's a deemed disability, so invariably it'll be yes. But that can be a very useful tool just so that they're fixed with that knowledge. They can also make practical suggestions, as I say, because they bridge that gap between the complex medical situation and the work environment. And often one of the issues is that people don't really know what they don't know, and they don't know what they need, because you're dealing with all these other issues in terms of your own personal health and your home life and things like that. And working out yourself what adjustments you need in the workplace is almost a bridge too far. You've got your mind on other things, and occupational health can help with that. They can either suggest things or they can tease things out because they have kind of medical backgrounds. And so no, the duty doesn't crystallize at any one point in time. Knowledge will crystallize, and once they're fixed with that knowledge, they have it. But if you have an evolving condition, then there's a bit of a responsibility in you to keep your employer informed about that, because they can only make new adjustments if you give them new information.
Thanks for that, Yvonne. That's two really important points for people with lung cancer. So I'll move on to the next question, which I think is Claire has got her hand up.
Yeah, I think it really answered it was the second part of Yvonne's question that I was really interested in. So my employee are going through a restructure. There may be redundancies next year, but if I went to apply for another job, what would I have to disclose? But I think, as you said, it's probably up to me what I disclose.
Yeah, Absolutely. I mean, I think that, yeah, there's no obligation to disclose your medical conditions at all.
Mm,
It is really about what you're comfortable with and whether you have needs that would be best met by,
mm,
disclosing them effectively. And again, I understand the very real concerns about disclosure
mm.
and about when you do that and the timing of that and how that affects relationships. And I think.
Yeah, I suppose I worry that your career's over if I get made redundant from the company I'm in, that, what can I do next? So without, anything be a detriment to me. So yeah.
Yeah, I mean, it depends on whether you, for instance, need adjustments in the recruitment process or whether
Mm,
you need adjustments immediately upon starting work. And if
hmm.
that's the case, then, having an open and frank conversation with your employer or your prospective employer may be the best way forward. For instance, if you need flexible working because you simply cannot go into the office 5 days a week, I mean,
Hmm.
realistically, you need to be open about that at the point of recruitment because it'd be the same, not to be comparatively, but if you had childcare responsibilities or you had caring responsibilities and you simply cannot go in the office, 5 days a week, your employer needs to know that.
Yeah, of
So things like
course.
that. But if it was, for instance, the adjustments aren't quite as necessary as that, and you want to wait until you're in established, then there's no
Hmm.
requirement. And
No,
it,
okay.
yeah.
Thank you.
I think we've got one more question here from Kate.
Can you hear
Maybe.
me now?
Oh, I can hear you now, Kate. Yes, you're
Okay,
coming through.
sorry.
No, no problem.
Came in late and now my tech isn't working. So I apologize if this was slightly covered at the beginning of the call. And I also apologize because it's a little bit of a morbid question. I'm just thinking about a hypothetical situation in the hopefully distant future where, you've maybe had to take some time out for difficult treatment and actually it hasn't worked and you might know at that point that you're near the end of your life. But don't want to leave your job because there are certain, benefits and payouts that, you would like to receive on the event of your death. Obviously, if that is a quick process, then it sort of works itself out. But if that process was drawn out for a long period of time and you sort of exhausted your sick leave, I'm just sort of wondering what might happen in that situation in terms of your rights to at least keep your job, even if it's with no pay, or at what point you've sort of exhausted what your employer being able to keep you on in the role. And I suppose you don't have to disclose that you're dying, but should people?
Yeah, I mean, again, there's no obligation to disclose. Um, I think that's the kind of the ultimate point. I mean, I think that the issue arises, as you say, if you're on sick leave and you've exhausted your sick leave, then what would normally kick in is the employer's normal absence management policies. And there's normally triggers about when they would start kind of performance management, also almost kind of, if you can, because effectively a contract is a two-way street. They provide you salary for you providing work. If you're no longer providing that work, is there an obligation to provide you with the salary or to keep you on their books with the benefits, which is what you're looking for. And so there will be an absence management policy which will kick in now with reasonable adjustments. The normal triggers can be adjusted as a reasonable adjustment because you've got more time off, because you're sick, because you have a protected characteristic, because you have cancer. And so those triggers may be adjusted and may be pushed out, and so that you have more time. But it doesn't mean that they have to completely ignore their absence management policies. There will come a period where a tribunal will have found it reasonable that they have waited as long as is reasonable, basically. And if you're no longer able to provide service to them, then they no longer have to keep you as an employee because you're not essentially fulfilling your part of that contract. And as difficult as that is the contract. And so adjustments will get you to a certain point to kind of effectively keep you on the books if there's benefits outside of just pay itself. Um, but as I say, those policies will kick in. I'm not sure if that's answered your question fully or not.
Yeah, no, that is helpful. Thank you.
Yeah.
Thank you, Kate, for bringing up. That's a difficult topic, but I think it's an important one. I've heard about people in my own network talking about wanting to stay in employment because there are death in service benefits, and that's something that they want for their families. So it's important to bring that up, although I know it's a difficult one. Any other questions before we close? We've run over slightly.
So my question is, you know, the way you're saying we come under a category of disabled. So say when you go into remission, do they still consider you as a disabled once you have cancer?
Yeah, I mean, I maybe skipped over that bit. There was quite dense, but yeah, it is. It's complicated. There's a lot of case law about when it starts, but there's case law that seems to establish that even if you're in remission and even if you have no cancerous cells, you're still deemed to be disabled. And therefore, so, you know, after treatment in remission, you would still be covered under the deemed disability of cancer. Now, in relation to harassment, it almost wouldn't matter because someone can harass you if they think that you have a protected characteristic. So, for instance, in a different example, if someone thought you were suffering from a different disability and was harassing you about that, and you didn't have that disability, or you weren't of that sexual orientation, that is still harassment. So, if someone thought you had cancer and was harassing you, even if you didn't have it, that would still be harassment. So that's relevant for just the case of harassment, but overarchingly, yes, I think that effectively once you have cancerous cells, you're effectively protected, you know, moving forward. And it's not a settled position, but the case law currently seems to say that.
Perfect. Thanks. No, and I did put up like that. I actually are from Ireland, and a lot of you are from England, and I'm not sure of kind of the law would be the same in Ireland. So I was trying to find myself somewhere along the way. Like your HRC, if there was a HRC in Ireland.
The Equality Act doesn't apply to Ireland, actually, and so it's England, Scotland, and Wales, and so it doesn't. There will be, I think there's separate equality legislation, and so I would have to look into that. I don't have it in my fingertips because I don't practice there, but yeah, I mean, hopefully it's somewhat equivalent. But a lot of the practical stuff that I've said hopefully will still have been useful. But the specifics of the Equality Act don't reach Ireland.
No, overall you're very helpful, and it's just I will check it out in Ireland myself and see, because I've never heard it in Ireland, so I just wanted to know myself then too. And I really appreciate your insight and all the other information.
No problem, thank you.
I think that's all the questions that we had. So looking at the time, we've overrun because it was such an important topic. So all remains for me to say is just a huge thank you to Colin for such an excellent presentation on such an important topic. And thank you for everyone here tonight. There's some really pertinent and valuable questions that I know will have helped not everyone in the room tonight, but when we use this recording as an asset on our website. So thank you so much, everybody, for coming tonight. And thank you, Colin. Bye.
Thank you.
Thank you.
Thank you very much.
Thank you so much.